Child Abuse Signs at Daycare, a guide for New York parents. Attorney Andrew M. Stengel. No parent drops their child off at daycare expecting abuse. However, abuse at childcare facilities happens more often than most people realize. In New York, families who discover their child has been harmed at a daycare have legal rights and they have options. This guide explains what warning signs to watch for, what steps to take immediately, and how a civil lawsuit can help your family recover. Physical and behavioral signs every parent should know. Children, especially very young ones, often cannot tell you what is happening to them. Therefore, parents must rely on physical and behavioral changes to identify possible abuse. Unexplained bruises, welts, or marks on a child's body are among the clearest warning signs. Additionally, injuries that the daycare cannot explain or explains inconsistently should raise immediate concern. Behavioral changes are equally important. For example, a child who suddenly becomes fearful of a specific caregiver or refuses to enter the daycare is communicating something. Sleep disturbances, regression to earlier behaviors like bedwetting and unusual withdrawal, or aggression can all signal that something is wrong. Most importantly, trust your instincts. Parents who may sense a problem are often right. What to do? Immediately, if you suspect abuse. First, remove your child from the daycare. Do not wait for confirmation or an investigation. Second, document everything. Take photographs of any injuries, write down what your child says, and note the dates and times of every incident you can recall. Third, bring your child to a pediatrician or child abuse specialist for an evaluation. In New York, you should report suspected abuse to the New York statewide central register by calling 1-800 342 372. Oh, additionally, contact your local police department to file a criminal complaint. These two steps, reporting to OCFS and to law enforcement, create an official record and trigger the investigations that your child's case deserves. New York's mandatory reporting laws and what they mean for daycares. New York Social Services Law. Section 413 requires daycare workers, teachers, and other childcare professionals to report suspected abuse immediately. These workers are legally designated mandatory reporters. However, daycares sometimes fail in this obligation, either because management wants to avoid scrutiny or because staff members are too intimidated to come forward. That failure to report is itself a legal violation. Furthermore, when a daycare facility fails to report abuse, it can extend the harm and allow the abuser to continue. As a result, the institution's liability in a civil lawsuit grows significantly when it can be shown that staff knew about the abuse and did nothing. In New York courts, this kind of institutional cover-up is taken very seriously. How a New York family pursues a civil lawsuit after daycare abuse. A civil lawsuit against a daycare operates separately from any criminal case. Even if the abuser avoids criminal conviction, the daycare and its parent organization can still face full civil liability. In New York, the legal theories most commonly used in these cases include negligent supervision, negligent hiring, and negligent retention of staff who posed a danger to children. Your attorney will investigate the facility's hiring practices, review any prior complaints, and obtain records from OCFS and law enforcement. Additionally, a skilled lawyer will identify every potential defendant, including the daycare operator, property owner, and any parent organization. That broad approach to liability maximizes the recovery available to your family. Documenting injuries and building the civil case. The strength of a physical abuse case depends heavily on documentation gathered in the days and weeks immediately after the abuse is discovered. Photographs of bruises, cuts, or other visible injuries should be taken right away. A pediatrician or child abuse specialist should evaluate your child as soon as possible. Medical records from that evaluation become a cornerstone of the civil case. Your attorney will use the OCFS investigation file, law enforcement records, the daycare's internal incident reports, and employment records for the workers involved to build a case against the institution. In New York, a daycare that substantiated abuse findings on its OCFS record faces a particularly difficult defense. That official record establishes that the state itself found the abuse credible. Combined with medical documentation and witness testimony, it creates the foundation for a compelling civil lawsuit. Contact the law firm of Andrew M. Stengel, PC Free and Confidential. The law firm of Andrew M. Stengel, PC, represents New York families in civil lawsuits against daycares and other institutions that failed to protect children. We understand the fear, anger, and grief that comes with discovering your child was abused by someone you trusted. Our firm exists to hold those institutions accountable and to fight for every dollar your family deserves. Contact us for a free, completely confidential consultation. Email info@stengelaw.com. For more information, please visit our website, stengelaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.